I'm Cynthia Rowland, and this is episode 134 of EO Radio Show. In today's episode, I talk with my colleagues at Farella, Ben Buckwalter and Jackie Gerson, about the nonprofit workplace and political speech issues. As most listeners are well aware, charitable organizations described in Internal Revenue Code Section 501c3 cannot engage in candidate campaign activities, and legislative lobbying is only permitted for public charities in limited amounts and limited circumstances. Other episodes of this show go into the details about the tax law limitations on political activities by exempt organizations, and they do vary depending on whether the organization is a private foundation, a public charity, a C4, or some other form of exempt organization. Today, however, we are going to talk about the employment law rules that nonprofit employers need to be aware of. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world, because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. The goal here on the EO Radio Show is to cover topics of interest to organizations that are tax exempt under Internal Revenue Code Section 501c, which includes public charities, private foundations, those are the 501c3s we're all familiar with, as well as social welfare organizations that are described in 501c4, business leagues, churches, and a myriad of other types of organizations. Much of our content focuses on the issues in the charitable sector, that is, public charities and private foundations, which have special restrictions on their political and advocacy expenditures. 501c4 organizations have a little more latitude, and the rules applicable to churches may be evolving as well. But today's episode is not focusing on the Internal Revenue Code rules. Instead, we're addressing the hot topic of political speech in the workplace and the employment laws that apply. To guide us through these issues, I've invited Ben Buckwalter and Jackie Gerson to go over the relevant laws and best practices. Ben specializes in working with companies to manage and mitigate employment law risks to achieve their business and nonprofit goals. He has deep experience defending employers in single plaintiff and class and representative action lawsuits related to discrimination, retaliation, harassment, leaves of absence, wage and hour compliance, and requests for accommodations. Through his experience defending employers of all sizes in litigation and as an in-house employment attorney, Ben always strives to understand what is most important to his clients in order to reach the best tailored resolution of the dispute for each employer. Jackie Gerson has represented employers against claims of discrimination, harassment, retaliation, and wrongful termination in state and federal courts. So welcome to the show, Ben and Jackie. I'm so glad you're here to talk about this with me today.
Thanks for having us.
Ben, why don't you start us out with a little overview of where we're going to go on this topic? It's pretty broad. We can't cover everything. Give us a little roadmap, and then we'll dive right into the substance.
Absolutely. Thank you, Cynthia. So we're going to start with an overview of the current laws against discrimination, harassment, and workplace political speech. And that will include some labor code sections, both in California, and we'll mention a few other states that specifically address employers' rights or restrictions against employers from monitoring employee speech. We will also talk about some of the Trump administration's early executive orders addressing political speech in the workplace. Next, we will go into some examples of how this has worked out in real life. And for that, we will use some current events topics as a frame to look at how this happens in real time. First, we will focus on the Black Lives Matter movement and some litigation that has resulted from employer attempts to allegedly employer attempts to restrict free speech. And then we'll go into some litigation addressing employees' speech in the workplace, specifically around political campaigning and what we've seen there. And then finally, we will talk about DEI policies. Many employers are wondering what is allowed now that the Trump administration has taken a markedly different approach from prior administrations. So we'll try to add some clarity there.
Great. to clarify to all of our listeners across the country, and in fact, we have listeners around the world. So some of these are very sensitive topics. And as employers and counsel, we try to walk that fine balance. The law is what the law is, and here's what the case law tells you. And so to you nonprofit organizations as employers, these are things to keep in mind. So let's launch right into it. We look at this from management side, employment lawyers, not the employees. Talk us through, set the frame a little bit. What are you seeing? What's the universe like for your clients who are mostly employers that come to you with some current issue?
Yeah, and that's a good thing to point out is that as management side employment lawyers, our first focus is always about how to mitigate risks with respect to any type of employee issue that might come up. So as you mentioned, that can be really tricky and sensitive when it comes to employee speech. One thing that we often hear employees say is, well, I have a free speech right to say this or to say that. The interesting reality is that when you're in the workplace, you don't actually have a First Amendment free speech right. That applies to government action. And here we're typically always talking about, whether you're an exempt organization or a for-profit company, you're not a government actor. That said, the way that employers approach speech in the workplace can have significant impacts on other types of risks, whether it's discrimination allegations or allegations of harassment in the workplace or potential retaliation for someone making comments that could be considered protected activity. Those are often the areas where we see sensitivities regarding employers' actions regarding employee speech.
Yeah, that's exactly right. That's what I have observed. I do want to make one comment. Some nonprofit organizations might technically have a relationship with a government agency, either being part of a government agency and so forth. So if that describes a listener's employer, then maybe there is a First Amendment right to be worried about. But I think for the vast majority of our listeners that are not government organizations, Ben, obviously you're spot on. There's special rules here. So let's just go right into that. What are these special rules that our employer listeners need to know about? Jackie, I think that we'll turn that over to you. I know you're an expert in these issues. Give us a framework of these state laws that apply.
Yeah, so California and at least 11 other states, including New York, Connecticut, and Colorado, have laws that prohibit employers from limiting an employee's political speech. California Labor Code also states that employers can't discharge or terminate employees for lawful conduct that occurred during non-working hours away from the employer's premises. So let's say, for example, a California employee attended a Trump rally and their employer then found out about that and terminated them because they went to the rally. That would violate these labor code sections because it would be seen as a limit on an employee's political speech. New York also has a similar labor code section, which prohibits employers from discriminating against an employee based on their political activities that don't involve the employer's equipment or property.
So these are state law-ish limitations only in some states, and they're not to be confused with freedom of speech. It's not a constitutional right. So that's the framework we're looking at.
Exactly.
All right. What else do we have?
On the federal level, as Ben mentioned, there's many anti-discrimination laws that interact with employee political speech. All federal, state, and local laws regarding discrimination, harassment, and retaliation make it unlawful to discriminate against an employee based on their race, color, religion, sex, and national origin to ensure equal opportunity in the workplace. So employers should definitely review the law in their jurisdiction carefully when addressing discrimination claims, which might come up in a political speech context. For example, California's Fair Employment and Housing Act places a duty on employers to investigate any harassment claim brought by an employee and take action if substantiated.
Let's talk a little bit about recent executive administration actions that we've seen. Those have been a really hot topic this year. How do they interact with the employment laws? Or I should say, not so much the employment laws. How do they interact with risk management as an employer when facing these difficult situations with an employee?
First, I think I'll just give a little bit of a brief overview and then we can kind of dive into the analysis further. But Like you've mentioned, the current administration has issued a number of executive orders which directly address workplace speech, many including DEI, gender identity, and anti-Semitism. But it's important to keep in mind that these orders don't change the law, while they may alter how the law is ultimately applied, which we are seeing in some cases. So the first Trump executive order is called Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The purpose is to end DEI efforts, which this administration refers to as illegal diversity, equity, and inclusion. So this order instructs federal agencies to end DEI in federal contracting and encourages private employers to do the same. This bars federal contractors from factoring race, color, sex, sexual preference, religion, or national origin in their employment practices, in what the administration says, quote, would violate civil rights law. This order has already pushed large federal contractors to dismantle many DEI programs that would have, for example, pushed companies to fixed outcome targets, such as recruiting a certain number of women or historically underrepresented groups. So the last Trump executive order we'll touch on today is titled Additional Measures to Combat Anti-Semitism. This order builds on a 2019 executive order Trump issued to combat the rise of anti-Semitism, particularly in schools and on college campuses. But this order from the current term, in the wake of the October 7th attacks, requires a, quote, government-wide effort to combat anti-Semitism. The EEOC acting chair has also promised to hold campus workplaces accountable for what she considers to be anti-Semitism under the guise of free speech and in violation of the First Amendment.
And one thing I've seen with respect to these executive orders from private companies, but also from exempt organizations, is the challenge between what happens when the personnel at a company strongly disagrees with the content of these executive orders, but feels that they have an obligation to comply with them so that they don't put their company in a tricky place or as a target for the administration. That can be an incredibly difficult line to walk, particularly when you're talking about something like DEI practices. There's no one-size-fits-all clear answer for how to address that, but it's always something that should be addressed carefully and often in consultation with key stakeholders at the company.
Absolutely. And so any other key takeaways from looking at this overview of the statutes? And then I know we're going to get into some specific nitty-gritty cases.
I think the other key takeaways will shine through when we talk about the specific cases.
Okay, great. Let's get right into that. I think we're going to talk about some cases that arose out of the Black Lives Matter movement. Jackie, you want to talk about a few cases there that are particularly interesting?
Yeah, there's a really interesting National Labor Relations Board 2024 decision that actually involved Home Depot with an employee who had handwritten letters on his work apron that said BLM, which stands for Black Lives Matter. Other employees at the same store also had these markings on their work aprons around this time, but Home Depot just terminated this employee for refusing to remove those letters. So to provide a little context, the National Labor Relations Act protects employees' right to engage in concerted activity for the purpose of mutual aid or protection. Basically, the NLRB found that the employee refusing to remove the BLM letters was constituted concerted action because it had to do with these prior employee protests about workplace racial discrimination. And because those protests were attempting to bring those complaints to management's attention, this conduct too was aiding their cause because it involved the working conditions experienced at Home Depot.
So this was speech in the company that related to actual employee, I'll use the word grievance. Maybe that's not the right word in employment law context. The employees together had already raised the issue that there was a feeling of unhappiness. And again, I'm using my lay language, not employment language. So this was an outcome in favor of the worker that he was unlawfully dismissed for not taking those words off of his apron.
Exactly.
So not really a free speech case, because Home Depot is not a federal agency. It was something specifically covered under the NLRA. Is that right?
Exactly. So employers can't really interfere with an employee's right to display protected insignia like the BLM marking here. That's going to be presumptively unlawful unless there's a special circumstance where that rule would be necessary for the employer to maintain production or discipline.
Okay, interesting.
And if I could add, one of the really fascinating aspects of this case is we already know that under the NLRA, employees have a right to talk about the terms and conditions of their employment. Now, this case took that, a step or two further, where they said that given what had been going on in the worksite before this, just the act of putting BLM on the apron was actually itself essentially speaking about the terms and conditions of employment, given what had gone on before, which I think is a really interesting aspect of this that is potentially replicable in other workplaces.
Yeah, absolutely. The next one that I think we're going to talk about, it also relates to Black Lives Matter, but is more likely to come up in a nonprofit context where people are, say, having podcasts and just saying whatever they want on social media. So, Jackie, walk us through the second BLM case. I think this one's in California also, right?
Yes, this one's also in California and actually arose out of a radio show that's based in Sacramento and covers the Sacramento Kings basketball team. So here, what's interesting is this is actually an employee's off-work comment made on social media. So the plaintiff here was a radio host, like I said. In 2020, a week after George Floyd's murder, a former Kings player asked the radio host on Twitter, now X, if he supported BLM. And the radio host responded saying that all lives matter. That tweet elicited many responses, a lot of them being critical and essentially calling for the radio host to be taken off the air. And so at that point, the radio show terminated his employment, and he filed a case claiming that that was an unconstitutional burden on his free speech. But what was interesting here is that this radio host is a public-facing employee whose job is to speak for the company, or for many of your clients, maybe for the organization. The radio host's comment went against the show's intended tone and style and really just irked the listeners of the show, which is a huge problem if you've hired this person for that purpose. So while this is a pretty narrow decision that wouldn't necessarily apply to other employees at the company, here the radio host's free speech, even on his own time, came into issue because it interfered with the show itself.
So the freedom of speech here, it kind of turned freedom of speech on its head, right? The speech that was being protected was the expression of the radio show, what it's all about, and having a key employee that made comments contrary to that affected the freedom of speech of the employer. So that is a really interesting twist. I don't imagine that comes up very often.
I can't say it does with other cases I've seen.
So that's a super interesting one. Actually, I don't think this next one is a case. We're just going to talk about those wonderful hats that we see all over. I'm not sure which of you wants to take that topic, but let's talk a little bit about MAGA hats at work.
Yeah, I can address this. Whether it's a MAGA hat or a Kamala Harris t-shirt or whatever it is, bringing your political identity into the workplace with this type of insignia can really inflame a lot of the sensitivities that we've been talking about. On the federal and government level, there are laws in place that say that, when you're on the government dime, when you're working in these public roles, you should not be wearing campaign materials. Now, on the exempt organization or the private employer side, it's a bit more complicated because you don't have those automatic laws that apply. But what we've seen is that when you have an incredibly charged symbol like the red Make America Great Again hat, whether you mean it as simply a support for the current president or for other things that president believes in, it can bring out a lot of significant feelings in other people in the office. And it can make them believe that maybe they are being targeted given their identity or the color of their skin or their religion, or whatever it is. We've seen a lot of really interesting litigation addressing these issues. And in one case, I'd like to point out, there was a direct clash between what we've seen about these laws protecting employee speech about their political opinions but also what the company is allowed to do in monitoring how they are being perceived. Essentially, there was someone who ran the social media account of a company that had a largely conservative client base. And that person wrote on their own personal social media account comment talking about the negative feelings they had about the Make America Great Again hat. They were ultimately terminated from their employment because of the clear nexus between their personal social media account and their social media activities for the company. They said that that was a protected activity that they took under the California Labor Code, which prohibits employers from restricting employee political speech. But the company ultimately said, well, we have our own free speech right to make sure that we are not portrayed in a way that could harm our business. Ultimately, the case settled out of court, so we don't know what a court would actually say about that clash, but it was a fascinating example of how this can play out.
Yeah, and I think in the, bringing this to the exempt organizations context, for charities and private foundations that can't at an organizational level, they risk losing their exempt status if they engage in prohibited candidate or lobbying. And just, supporting an elected official is neither of those things necessarily, but it could be. So those organizations, their employee handbooks for ages have said, you're free to do whatever you want on your own time, but the organization can't engage in these types of activities. And so I guess, where the rubber really hits the road is if it's a key person that steps out of bounds on their own private social media, can the employer be protected? And it sounds like in some cases, yes, right? It's all going to depend on the facts and circumstances.
That's exactly right. In some cases, yes, it will depend on the facts. But ultimately, many times, even if you're absolutely right in the law, the best and the most cautious approach is to avoid these types of lawsuits, which just warrants consideration of how these rules are applied.
So with my risk management and advising the company hat, I'm wondering if this is making you take a closer look at employee handbook provisions and maybe also to executive contracts. For certain key jobs and job descriptions, maybe you write some of these things in that your job description includes being the public face of the company. I don't know if that would help the employer or not.
I think it could. That kind of drafting, especially for executive type employment agreements, should always be considered really carefully. But getting all that out in the open early can really help with respect to how this plays out. Another consideration, just because so much of what we've talked about today has to do with social media, many companies are considering, do we implement a social media policy? Do we get rid of a social media policy, given all the sensitivities right now? There's not one clear answer to that, particularly when you're dealing with this employee's political speech issue and how it contradicts with the NLRA, and it's saying that you have a right to talk about the terms and conditions of your employment. Long story short, there is a way to draft these social media policies that is compliant with all those considerations, but oftentimes the ones you might download from a website don't get those nuances exactly correct.
Really tough calls here. So let's wrap up with something that's just as tough, and that is thinking about employee speech and DEI policies in particular. Another very relevant and timely. I mean, you can't read the news any day without coming across somebody's opinion on one side or the other of this. Any kind of wrap-up comments that brings this all together under the current events in DEI as an employer, always with the employer perspective?
Of course. I'd like to loop back to one of the things Jackie mentioned at the beginning, which is that the laws against discrimination, harassment, and retaliation still apply. Regardless of what the Trump administration says about their own preference about DEI policies currently, at least on the state level and even on the federal level, are still permissible. You just need to be careful about how they're drafted. Some employers have decided they want to distance themselves from DEI policies. That is a perfectly fine company approach to take, if that makes sense for the company. If other companies want to keep their DEI policies, that is also a great approach to take. so long as you take a close look at what the language says and make sure that it doesn't directly go against any of the Trump administration executive orders. Because even if you are completely compliant with California law and completely compliant with longstanding federal law, you don't want to put yourself in a position where you could be perceived as violating a Trump administration executive order. It's always a good practice to speak to counsel and make sure that the language is up to date.
That's a great way to wrap it up. Any closing thoughts or best practices from either of you that you'd want to mention? If there's one takeaway from today or two, what do you want your employer clients to keep in mind as they're facing these tough issues? And I guess maybe a better way to phrase it is, if they see something coming down the pike, what should they do?
Well, first of all, I think it's really important to just stay attuned to what's going on. These things change from week to week, from month to month, unfortunately. So if you see something coming down the pike, you're already doing half of it right. And then once you do see something, the best approach is always to reach out to your counsel or key stakeholders at your company. Maybe you have a board that you're responsible to, and align on the best strategy going forward. Sometimes there can be too many cooks in the kitchen. Lots of times, many voices help come to the best approach.
Yeah, that's wise. That's a very wise approach. Well, thank you both. I really appreciate your time today. And I think these are such hot topics, such difficult issues. And maybe we'll talk again in 6 months or a year and see where we are, right? If there's anything constant about employment laws, that it changes.
That's exactly right. Thank you, Cynthia.
Thank you.
So that's all for this episode. Be sure to check out the show notes for links to more resources and for organized playlists on this and other related charitable topics. The Farella YouTube channel has all of the charity resources in a number of really useful playlists. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.